Reddy Neumann. I'm the managing partner of Reddy Neumann PC, and with me today is Stephen Brown, who's also a partner at Reddy Neumann PC. It is a Friday. It is our casual office day, and we are sporting our favorite sports teams in honor of the Super Bowl happening this weekend. So please disregard our clothing. But I am my Detroit Lions. I'm a fan. Yes, I like the Houston Texans too, but I'm a Lions girl at heart. Stephen, who are you supporting today?
Yeah, so I have the AAA Corpus Christi honey butter chicken biscuits here, the the double A affiliate, excuse me, of the Houston Astros. I just love the jersey and figured it'd be a fun one to wear today.
All right, go Whataburger. So what are we here today for on a Friday afternoon? So there's been some updates to the unified agenda recently that we wanted to talk about because they specifically are impacting employment-based immigration, both on the non-immigrant temporary work visa side and the immigrant green card side. So first off, what the heck is the unified agenda? Why are we even worried about this? It is basically a list of planned regulatory actions that all of the different executive branch administrative agencies are planning to do. So it comes out in the spring and the fall. We're actually operating off of the fall 2023 unified agenda, which came out last fall, but they've added two new possible regulations to it. So those are what we want to talk about, as well as a prior regulation that's expected to be proposed pretty soon that deals with adjustment of status. So the point of having this agenda is to, show transparency so people are aware of what the different government agencies are planning. And so people can engage and be, part of the regulatory process. So Department of Homeland Security, which is USCIS, CBP, and ICE, Department of State, Department of Labor, these are all executive branch agencies. So they all have to put any planned regulations in the unified agenda before they actually get published. Now, one thing with these proposed regulations is we think it is related to the executive order on artificial intelligence and emerging technologies that Biden put out back in October. So, Stephen, can you give us an overview of what was that and what kind of...
Yeah, absolutely, Emily. So October 30th, we get an executive order about AI. And this was AI and emerging technologies. It was across the board to direct multiple agencies, but it had a lot of immigration provisions that I thought were interesting. And the big one, I think, why we're seeing the regulations we saw get added to the regulatory agenda was that within 90 days, which was about now, the Secretary of State, Homeland Security should be taking steps to streamline the visa petition process for non-citizens that are working, studying, or researching AI or other critical emerging technologies. And I think that's the big one why we're seeing this today, which we'll talk about what we think they've done. And there were some other provisions as well within 120 days. Consider rulemaking to establish new criteria for the DOS exchange visitor skills list as it relates to the 2-year residency requirement, update the 2009 revised exchange visitor skill list, and consider implementing a visa renewal program to facilitate the ability of qualified applicants to work in the U.S. and get their visas in the U.S. And we're already seeing that pilot program start. The other part of this, 180 days, Secretary of State is to consider rulemaking to expand categories for domestic visa renewal to include J1 and F1 students in STEM fields, and then establish programs to attract talent. And so really what we've seen, and then I think one more, I apologize, 180 days, work with putting forward policies or other means of working with these AI for O1 visas, EB1 visas, EB2 visas, startups using the international entrepreneur rule and continue the modernization. And then finally, working with Department of Labor on updating Schedule A, which has not been updated in a long time. And so I think what we're finally seeing is what the agencies are wanting to do to enact President Biden's order. He wants us to not be losing the race on AI and these emerging technologies. We should be leading this. And unfortunately, one of the hurdles is immigration. So let's create systems that will make the immigration pathway better for experts in these fields.
All right. So first, let me remind everyone that we don't have the proposed regulations yet. We don't have the actual words of what they're planning on doing. This is just new things published in the Unified Agenda that give us a hint of what they're going to propose and a possible timeline for when that's going to happen. So that's what we're going to discuss. Our interpretation of what we think it's going to be. Apologize in advance if we end up being wrong, but I think we've got a pretty good sense of kind of what they might be doing, because whenever they publish anything, whether it's policy guidance, update to the manual, whether it's a regulation, whether it's a statute, they use very specific language. And the specific language they use has very specific meaning. So when they use the word immigrant, that refers to immigrant petition, for example, that refers to an I-140 for employment-based or an I-130 for family-based. It does not have anything to do with H-1B or TN or any other non-immigrant visa. So they used specifically the word immigrant petition. And then they have another one that's non-immigrant. So we know that that specifically is going to be dealing with H-1Bs or other temporary work visas. And then they specifically refer to dependent spouses in one area. And then another one, they refer to derivative beneficiaries, which means it could be spouse or kids or both. So based on these specific words they've used, they've kind of given us an idea of the roadmap of what they're planning ahead. We may not have all the details, but we have a general idea of what we think it might be. So we're going to start off with the petition for immigrant worker reforms, which was newly added to the Unified Agenda. This is expected to be proposed in August 2024. So I know that we're a long way off. They still have to propose it. It's going to have a notice and comment period. So we'll all give our comments. Then they're going to take those comments back, decide what the final regulation should be, and then actually publish it, or even decide not to publish it if they get a lot of. Go ahead.
Yeah, if I can add, yes, they have said August of this year, but that's not binding, right? That's just, hey, we have this on the agenda. We saw, what was it? There was an H4 provision that hung on forever and kept getting pushed. There's been others. So if August comes around and it's not on there, it's not mandatory that they put it out there.
Yeah. All right. So what are we talking about for immigrant petitions? So this is specifically referring to EB1, EB2, and EB3 immigrant petitions, which means I-140s. Now, the last time we had a major, which wasn't really major, but we had some kind of update to immigrant petition regulations was really 2017, when they came out with a regulation to try to make things better, specifically for EB1, 2, and 3 specialized workers. That's when they added the 60-day grace period. That's when they confirmed things better for AC-21 and kind of codified regulations that had been 20 years in the making. So now we are 7 years later, and we're getting another update. We think that much of this is to do with the executive order on AI, but also just getting up with the times. I mean, since the last regulation, digital media has gone crazy. Social media has gone crazy. Blogs are very popular. So when we're talking about O1s or EB1As or things, they still refer to like microfilm and microfiche in terms of submitting documents and evidence. So I think that's kind of part of it, is updating some evidentiary standards in terms of what actually is happening in the real world in technology and emerging technology and AI. So first thing they want to do is codify. Codify means we're going to take what our current policy is and actually put it in the regulation in writing, going through the proper notice and comment procedure, because they put out these policy guidance, they put out updates and explanations on their website. They're not really law yet until it gets codified. So they're going to take current policy guidance and implement administrative decisions specifically regarding successor and interest and ability to pay. These are both issues that come up with I-140s. When you have an I-140 employer who merges with another company, that gets sold to another company, a business unit merges into another company, any kind of merger acquisition situation, we have to look at, is the new company a successor in interest? And if it is, they're required to file an I-140 amendment. However, none of that's in the regulations. Even the definition of how to prove that you're a successor in interest is not in the regulations. It's in the policy manual. So I think they're going to update that. And then ability to pay, they recently came out with updated guidance on ability to pay not too long ago. And so I think they're going to incorporate that into an actual regulation. One thing I'm hoping is, because they're specifically talking about successor and interest where an I-140 has already been filed, and maybe they'll think about eliminating some of these documentation requirements for successor and interest in downgrades, where we're literally refiling the whole thing based on the exact same labor certification, same job, nothing has changed. So maybe if they don't propose that, I'm definitely going to be recommending it, because they want to implement administrative decisions and basically make things more efficient. So that's one of the things. They want to update provisions governing extraordinary ability and outstanding professors and researchers. So this is EB1A and EB1B. We think, again, that this is related to the STEM policy guidance that came out a while back, plus the AI executive order. So hopefully they will take into account new technology, and just the fact that proving someone has extraordinary ability now is way different than what it was years ago, because social media didn't exist, and you can definitely prove some kind of extraordinary ability based on social media, I think.
And that's been a policy, right, of using internet resources or things like that to show some of the EB1 criteria, but it's not written anywhere. So I think this, let's get with the times, like you said.
Yeah. They want to modernize outdated provisions for individuals of extraordinary ability and outstanding professors and researchers. Again, that's EB1A and EB1B. Same thing, I think outdated, they're referring to asking for documentation on microfilm and microfiche, so hopefully they'll get up with the times there. Clarify the evidentiary requirements for EB1, EB2 NIW, and physicians of national and international renown. So again, I think that is letting people know that, yeah, there's new types of evidence out there that didn't exist before that we will accept. So in our office, we've been using this type of evidence for some time to get approvals of EB1As and NIWs. But that's kind of just based on our creative lawyering, I think, knock on wood, I don't know. And so now I think they're going to actually come out with examples of the types of evidence that you could use. And then one other one is a little interesting. They want to implement reforms to ensure the integrity of the I-140 program. That one's a little weird to me, because I wasn't really aware that there's a problem with the integrity of the I-140 program. I think it's not something that's subject of abuse, like maybe some of the other, like the H-1B lottery was. So I don't know what integrity they're concerned about. I think that generally means more enforcement, FDNS, those kind of things, to look into fraud more. I don't know if you have any other comments on this particular provision.
No, I mean, I think every time we're going to see major changes, we're going to see something about integrity and enforcement, right? That's the big thing that everybody wants to cut down on, is fraud or misrepresentation. So I'm not surprised to see it. And we'll have to see what the regulation ends up saying, but that doesn't surprise me when they want to say, oh, we want to watch the integrity of the EB1 program or the EB2, EB3 program.
All right. So the other major one, the new one, is modernizing regulations governing non-immigrant workers. So Stephen, can you give us an idea of what they might mean with that?
Yeah, so absolutely, and like Emily said, the big thing is this is words have meaning in the immigration context, and so when we're talking about non-immigrant workers, we are talking about H1s, TN, Ls, Es, Os, Fs, maybe, all those types of things that are temporary visas, not green cards. This is a proposed regulation where we're expecting the proposal in October 2024. Again, that isn't set in stone. So this is proposing to amend its regulations regarding certain non-immigrant workers. Um, I really think when we saw this, and Emily and I were talking about this, a lot of this is some of this is going to come from policy. I think Emily, what do you think? Some of this is looking like it's coming from the bill that we saw that died, the border bill that had some provisions in it. We'll talk about that. But one of the first ones that they've put in the abstract here is updating the employment authorization rules regarding dependent spouses of certain non immigrants. We saw in the border bill a proposal to make H4 incident to status. I think because of how much discretion Department of Homeland Security has when it comes to work authorization. And we've seen court cases fought over that, right? The H4 EAD rule, the OPT rule, the STEM OPT rule. They have a lot of discretion. One of the things we think that this regulation could be is making H4 EAD for spouses incident to status. So, what does that mean? Right now, you have to apply. When you qualify, right, your spouse has the approved I-140, you have to apply for an EAD. That can take months. It could be done concurrently. It could take a long time. If they make it incident to status, so long as your spouse has the approved I-140 and you're maintaining your H4 status, you can work. You don't have to go get that EAD, pay the extra fees. And I could see them making that decision because that would be updating the employment authorization rules for dependent spouses. This is was in the negotiated border bill that had some provisions for high skilled immigration. So I could very well see this being implemented through regulation. Will it go to other categories? Probably not. I mean, E and L already have work authorization incident to status. TN doesn't have as much of a backlog issue, and then there's immigrant intent questions and all that. Maybe O spouses, as they're trying to get in more high skilled AI folks. But I think we could certainly see some good changes here for the community. The next one is increasing flexibilities for certain non-immigrant workers, including those who resign or are terminated from employment. So we know that there's a 60-day grace period for non-immigrant workers. USCIS has put together this whole web page of options for non-immigrant workers who are terminated, right? There's a lot of layoffs happening right now in a bunch of sectors. And USCIS put this out March 2023. All these options. Some of these were out of left field options that they kind of came up with, which are great. They have the idea that you can file the B visa, look for your job, and hey, if that B visa is pending and you file the H1, we'll do them together. That's tremendous because that's a game changer. We used to not recommend the B visa route because the B visa is going to take forever. You're not really in status. And so you'd have the consular process. And the fact that they've created a policy to fix that is great. Now, if they're going to codify that in the regulation, it makes it even stronger. It makes it more binding on the agency. So it's not just policy, which means their adjudicators are going to get more training. One of the things we may see, Emily, a longer grace period. I know that was a proposal by the committee that's working with the White House on Asian and Pacific Americans, if I'm remembering. I can't remember the acronym. The W.
Yeah, it's a really long acronym.
But the group that is kind of advocating for some changes, especially for the backlog community, one of the things they said is, hey, 60 days is not long enough, right? That's 2 months to find a new job. Let's say, especially you get terminated in November, nobody's really doing a lot of hiring in December. And I think their proposal was 180 days. I am not saying, I want to be clear, I'm not saying we're going to have a 180-day grace period. But that was part of their proposal. And so that would increase the flexibilities for certain non-immigrant workers. One of the others that I have hypothesized is that the regulation on the 60-day grace period is sort of vague. It says upon the cessation of employment. Now, I think lawyers that can get creative, going back to Emily's idea, there's a lot of ways to have a cessation of employment. But the most common way we see the 60-day grace period used is a termination. But what about a resignation? What if you're just not happy or you need a break? Can you qualify for the 60-day grace period? I think there's certainly arguments for it, but it's potential for them to add it. And I've gotten a couple comments here about my orange shirt looking like a prison. I do apologize. It is the Corpus Christi AA team. I am not a prisoner at this office, and I'll blink twice to confirm it. But yes, not the most aesthetically pleasing. I know. One of the other provisions, getting back on a topic, does involve religious workers. And I have to be frank, this is just not a topic I know as much about, but I know there was a massive change in how EB4 visa bulletin is handled. And there is a max out for R1 religious workers. They can't extend like H-1Bs if they've got an immigrant petition and it's just not available. And so they can't file the 485. They can't extend, right, like H1. So maybe they'll come up with something there for religious workers. And then they say additional measures to modernize policies and procedures for employment authorization documents. This, Emily, I think could mean a lot of things. Could they mean auto extensions? I mean, we have L2 incident to status. We have E-spouses incident to status. But what we don't have is any sort of automatic extension. And one of the things we tried to propose and we fought in some of the H4 EAD and the L2 litigation is that H spouses get that 240-day automatic extension, right? When you file the extension and it's timely, you get 240 days to work while it's pending. And considering that the adjudicative factors are very similar and there's not a lot of denials on H4s, why not them? It doesn't make sense to not give it to them. So maybe they're going to go back and rethink their regulations and give an automatic extension. To me, it makes sense that if that the H1 spouse is in that 240-day window of work authorization, why shouldn't the spouse, especially if the agency is going to take as long as they are? I think if the agency could promise a 2-week turnaround, okay, like figure that out. But when we're talking about 6-7 months on some of these, I think it's necessary to maybe add that. Potentially auto extensions, the incident to status, like we talked about, and we'll see how this works. But I'm really interested to see. I think this is a step in the right direction. And I think by putting these, Emily, in regulation, I think it's very forward thinking of the Biden administration. We're in an election year. And if it's just policy, that can change in the blink of an eye, right? They could just erase policy. If it is regulatory, it's a lot harder to change. Not impossible, right? They can certainly change it through their own. But in order to overturn regulations, you got to go through notice and comment again. So I think this is very forward thinking of the Biden administration of saying, look, here's things we want to get done. Let's do it. And make sure that these people are protected.
All right. And the third one we want to cover is not a new one. It's been on the fall regulatory agenda since it first came out, but it is relevant because it is improving the regulations governing the adjustment of status to lawful permanent residents and related immigration benefits. So this is I-485 adjustment of status. These are expected to be proposed March 2024. Next month, we might have a proposal that seeks to improve things for I-485. Now, what might they be seeking to improve? One is permitting the concurrent filing of the visa petition and adjustment of status for that employment-based fourth preference, which is your religious workers, because they currently cannot concurrently file even when the priority date is current. Another big one, permitting the transfer of underlying basis of a pending adjustment of status application. Why is that big? We already do that, right? That transfer of underlying basis, everybody did it after October 2020 when EB2 became current again for people and EB3 was backlogged. Everybody did the transfer of underlying basis back to EB2. That's been there in policy. It literally is from a letter from INS to an immigration attorney back 20 years ago stating, yes, we'll allow this in situations. Then they put it on their website after the October 2020 debacle. So now I think they're going to actually codify that, put it in the regulations, put some guiding principles for how it is to be done, and hopefully give us some more clarity about when is it actually accomplished. Because right now, like you send in that transfer of underlying basis, the I-485 supplement J, goes into a black box. You don't know what category you're considered in anymore. Do we know if they're an EB2 and your date's current and they're just delaying? Or are they still considering you an EB3 and they think your date's not current and that's why they haven't adjudicated your case yet? So hopefully we'll get some more specifics on what they are doing with these transfer of underlying basis requests. They also want to amend the definition relating to ineligibilities under Section 245C of the INA. What the heck does that mean? So that particular section is the statute. That's the law. The INA, the Immigration and Nationality Act, is the law that governs everything that we do. In the INA, there are specific provisions related to who actually can file an adjustment of status. So not everybody can file an adjustment of status. If you are not in the country legally, in a lot of cases, you cannot file an adjustment of status. You have to consular process, you might need a waiver, there's all these other things. But there are specific things like if you're an employment-based applicant and you're not currently maintaining a non-immigrant status, you cannot file for adjustment of status unless you qualify under 245K, which is a little 180-day provision that will overlook a gap of status of up to 180 days. Or things like that. So it's very specific. So they have this laundry list of the people who cannot file adjustment of status based on these different eligibilities. One of those is you cannot file adjustment of status unless an immigrant visa is immediately available. That's the whole thing. That is why when people ask, why can't we just file the 485? Why can't they just make all of the dates current? Because the statute says we cannot accept an adjustment of status I-485 unless there is a green card immediately available. Well, maybe they're going to redefine what it means to be immediately available. That's exactly what they're doing, is amending the definition relating to certain ineligibility. So maybe, I don't know. I hope that's what it is.
Yeah, definitely.
It might be minor. It might be just them saying, yeah, the filing date is what means the green card is immediately available, because before it was always only the final action date because there was only one date. Maybe this has to do with aligning things with the Child Status Protection Act, where they had modified last year and said, we'll accept the filing date for certain cases with the Child Status Protection Act. Speaking of that, they also want to clarify when a visa becomes available for purposes of calculating the age under CSPA, Child Status Protection Act. So we think that is them codifying using the filing date chart in the actual regulation, because right now it's just policy. So if Trump comes in, he could just reverse the policy, versus if we get that in a regulation, it's a lot harder for the next Trump to come in and change that. This one is interesting. Authorizing compelling circumstances EADs for certain derivative beneficiaries waiting for immigrant visa availability. So we know there's a compelling circumstance EAD, right? But it's generally for the main applicant, the person who has the I-140 approval. And if that person gets it, then the spouse qualifies for it. So we think perhaps it might be authorizing spouses on their own to qualify for this compelling circumstances EAD. Now, I know a lot of spouses qualify for the H-4 EAD, so maybe it's not that helpful, but they specifically say derivative beneficiaries. They didn't say derivative spouses. So I think maybe they're going to allow kids. I don't know. You know, these teenagers that can't get a summer job, they can't do their internship. I don't know.
And to that point, Emily, I mean, when you and I were talking about this morning, in the non-immigrant regulation that just kind of popped up, they specifically say derivative or dependent spouses, and here dependent beneficiaries. And like you said earlier, words have meaning. And so hopefully these words do have meaning, and hopefully we see some changes. Because like you said, I think right now, children derivatives don't have any option to work, right? Until they get the adjustment of status pending, or they get their own non-immigrant visa category. And that's really tough for, like you said, teenagers who want to work that summer job, or, hey, I need an internship. So
when all their friends are going out and working at McDonald's, or, you know, they're in college, a lot of these kids turn 18, they go to college, they're not 21 yet, so they're still on H-4, but they can't get those summer jobs like everyone else they're going to school with.
Yeah, so I think that would be helpful. I know this isn't, you know, strictly the I-140 EAD that a lot of people would have hoped for, but, you know, I'm happy with, you know, small steps are good. And, you know, we don't know exactly what this will say, but small steps are good.
Better than no steps, for sure.
Absolutely.
And one other thing they want to do is amend regulations related to temporary protected status, which is TPS for certain countries, and dealing with travel authorization, advanced parole for them, and how they can potentially qualify to file the I-485 adjustment of status. Because right now there's some weird, finicky things about whether you can file for a 485 if you're on TPS compared to a normal non-immigrant status.
And I think that's this policy too right now, right? Mm-hmm. That you can. Yeah. And so again,
I think it's based on a court case even.
Yes.
It was their choice. They were forced. So all of that to say, USCIS, Department of Homeland Security, says the intent of these changes is to reduce processing times, improve the quality of inventory data provided to partner agencies, i.e. Department of State, reduce the potential for visa retrogression, and promote the efficient use of immediately available immigrant visas. So with that intention in mind, hopefully they will actually propose some things that will help that happen. We've got some questions here, so we'll try to get to those. Not every question is relevant to this topic, so we're only going to focus on the ones that are with this topic. Let's see here. Any timeline for implementation? So again, they're all different. Right now, the first one coming up is the last one we talked about, modification to adjustment of status policies. And then the ones regarding EB1, 2, and 3 I-140s, proposal, maybe August 2024, not a final regulation, but we'll just find out what they want to do then. And then the non-immigrant workers, which is going to be your H1s, H4s, L1s, L2s, all of that, October 2024 is the earliest we might expect to see that proposed regulation. And until we actually get final regulations, none of this is changing anything. This is just advance notice of things that they might want to do.
Somebody had asked about the links. Emily has posted them. We've got them up on our social media as well. Or I put them up on mine, and I think we'll get that retweeted out. But yeah, they're online at the Federal Register. Again, like Emily said at the top of this, the two of them just popped up. I mean, nobody. They just kind of popped up yesterday. They were not on the original regulatory agenda because we had written an article about that.
Yeah, and I think that's directly related to the STEM AI executive order. Just the timing lines up with that. Somebody asked, when can we expect the rest of the final rule on H-1B, employer-employee relationship, self-sponsored H-1B, and all of that? We don't have any updates on that yet. So the unified agenda does have when proposed regulations are expected, as well as when final regulations are expected. They have not updated it yet with when they might expect that final regulation. It's possible we won't see that update until the spring agenda comes out, which might not be till like May or June, if I recall. It's not really spring by the time it actually comes out. So it might be some time still before we get that.
Question from YouTube. Any chance for EAD AP for qualified AI workers with the approved I-140 because of these regulations? I don't know. I think if I had to read the tea leaves and kind of seeing how things have gone, I could see them putting forward the regulations that they have, kind of policy, making it easier maybe for EB1A or EB1B or EB2 NIW. I know that doesn't really help the Indian backlog community, EB2 NIW, but the EB1 is not terribly backlogged. It's still backlogged more than I would like it to be, for sure. But hopefully they kind of make it easy. And who knows? Maybe they do come up with better alternatives and say, hey, we are going to create a work category. I don't know. But they are, it looks like, pressing on with President Biden's orders to focus on this AI and emerging technologies so we don't fall behind other nations.
Another question is, if we do the H-4 EAD incident to status, do we think they would try to cover that fee? Because obviously with all of these EAD applications they're getting money from that, which they use to clearly not process the applications. They use it for asylum or whatever else. But the one thing to think of here is there are lots of different types of EADs, and most of them, except for the ones associated with a 485, most of them have the fee that you have to pay. So this is just a small portion of them. So I don't think it would have that big of an impact on them financially.
And remember, Emily, when we had the lawsuit that we did that changed E-spouses and L-spouses to go incident to status, there wasn't this immediate, we got to change the fees here for others to recoup this. So, I think maybe we see what they want to do in the regulation on this, but they did just set forward their fee regulation. EADs are not the biggest revenue generator for the agency. I'll say that.
Let's see here. Any proposals in the unified agenda for documented dreamers? Not that I see at this time. Other than this potential for compelling circumstances EAD possibly being available for kids. We'll have to see what it comes out, but that's where the language becomes very important, because in one, they very clearly say spouse, derivative spouse. And in this, they say derivative beneficiaries. I have to think that there's a reason for that, which means they do intend to include kids in some way. So that may be the best bet, but we'll have to see.
And I know it's not directly related, but I'll address it because it's been asked. Are we planning on a lawsuit on the asylum fees? Not necessarily, but I am part of multiple working groups that are exploring this opportunity. I don't think it would be our firm directly because we can't. I don't think we have the standing as a firm to challenge it. But I am
sure we'd be harmed by it. Since we're
right. I think that I'm part of multiple working groups that are addressing it. I know one that is being worked on already, and others that are in the process. I would be surprised if that gets implemented on April 1st.
And then this one, if these regulations are actually like published, but they're in their 60-day waiting period to take effect, and there's a change in presidency, would they still go through? So I'm going to have to go back to my article that I wrote when we transitioned from Trump to Biden, because I do remember writing an article about what would happen to all of Trump's different regulations that were at various stages. And I think there was a way for the new administration to stop it from actually taking effect. There was some midnight regulation provision. Do you remember
I
that?
think he was able to do something where he said, hey, we're going to review all these that aren't final yet, and we're going to basically pause everything. If you remember, even in the first regulatory agenda from the Biden administration, it still carried over the Trump administration getting rid of the H-4 EAD. And that wasn't anything Biden wanted to do, but it just hadn't gotten cleared off the books yet. But I think there is a mechanism for the new administration to pause things that aren't finalized yet.
All right. Let's see here. One or two more questions. When might this be passed, and what are the chances of getting passed? So this isn't a bill, so it's not anything that has to go to Congress. It's a regulation, which I know I'm being ticky-tacky on that. But so this is something that the Biden administration can do. They just have to follow the process, which is publish a proposed regulation, ask for comments, review those comments, decide if any changes are needed, publish a final regulation, and then it takes effect. So I don't see anything in here that the Biden administration would not move forward on. So I think it's more a matter of when than a matter of if, and if they can get it done before anything happens with the election in case he doesn't get reelected. So yeah, I think I do expect them to ultimately go through if they can get done in time before any changes in presidency. And then
we've seen some recent court cases that support a lot of this. I mean, we've seen that the executive branch has broad authority on work authorizations. I mean, we saw, like I said, the STEM OPT, the H-4 EAD lawsuits, that there's a lot of authority here. So some of these tweaks that they want to make, I think, are well within their authority.
All right, last question. So H-1B spouse, will they get automatic work authorization? So we think that if the H-1B holder has an approved I-140, where the spouse now can get an H-4 EAD, we think they want to make that H-4 EAD incident to status, meaning, yes, they would have work authorization, but they don't have to apply for an EAD. It's just part of being an H-4 for those that have the approved I-140. I'm curious how they would note that, because remember when they did that for Ls, they had to go make this big scheme to have it say L2S instead of L2Y for the kids, so the kids wouldn't think they had work authorization. So I'm curious if they would do the same kind of thing, but then you have to note whether they have the I-140 approval or not. Who's going to judge that? So that might be a little more complicated, but all right. I think that is about it for today. Thank you everyone for joining us on this lovely Friday. Enjoy the Super Bowl this weekend. I'll be cheering on the Lions. I know they're not playing, but got to put my plug in for Detroit.
So are you going with the 49ers because they beat them, or what?
I'm going to say it, and people are probably going to hate on me for it. I'm kind of going for the Chiefs. I watched the Netflix quarterbacks show.
Yeah.
And I just was really impressed with Patrick Mahomes. So
always liked him and the guys around him, and little Taylor Swift, Travis Kelce, fun.
All right. Have a great weekend, everyone. Thanks for joining.